Thank you, Thomas, for your cautious optimism on sustainable indices. And now we have Georgina Tsagas from London talking about the Delphic Oracle for the EU Takeover Directive. The floor is yours.
Thank you. I have a rather poetic title compared to the rest of the presentations. Thank you very much to Beate for organizing such a great conference, and to everyone who has provided very insightful speeches to date on matters that I wasn't aware of. Slightly on a different topic compared to previous discussions, I will be talking on the Takeover Directive. And I've chosen the title Delphic Oracle because, as many of you may be aware, ancient Greeks and Romans used to make decisions and pray to the gods that they made the right ones. But for decisions of utmost importance, they used to go to the Delphic Oracle, which was quite famous because it had great authority in what it said, but also very ambiguous. So this is why when looking at the UK debate to get some answers as to what went wrong or what is wrong with the directive from a sustainable development perspective, we must do so with caution, because also the UK debate is slightly ambiguous itself. So, before delving deeper into the exact problems that I consider should be rectified in the directive, a few points to be made. The directive was adopted in 2004 and to be implemented by member states by 2006. And in 2007, the Commission issued a report indicating the directive's early failure in terms of it not effectively facilitating takeovers, which was one of the Commission's goals, and creating a level playing field. Article 20 of the directive provided that the Commission would actually in 5 years evaluate the application of the directive provisions and consider whether a revision was in fact necessary. So therefore, all the academics studying the directive were very eager to see what the study would say, and they were excited that this study would offer some concrete solutions as to how we should move forward. So last summer, I remember myself waiting for this report, and then it did come out in June 2012, and it actually was quite insightful as to the rationale and the application of the rules, but failed to offer some concrete solutions as to how we should move forward, especially from a sustainable development perspective. And this is why it's important to look at the UK debate, not so much because of the proposals that were prompted by a takeover I will analyze in a bit, but because it opened up a discussion as to whether the rules that are based on a shareholder primacy notion are in fact effective, and what should be done to rectify this. So in 2000, I don't know who likes chocolate here? You can raise your hand, that's great. In 2010, of course all the UK scholars will be aware of this, but in 2010 we had a takeover of Cadbury's, which is a very popular brand of chocolate in the UK, by Kraft, a multinational company based in the US. And funnily enough, this deal prompted the revision of the takeover rules towards, for UK standards, a more stakeholder-friendly model, and opened up a discussion as to whether, as I mentioned before, the provisions of the City Code on takeovers and mergers is effective. And the reason for looking at the code is because the code was in fact used as the model to draft the Takeover Directive. So it's quite interesting to see what the debate in the UK focused on, because then it can lead us to understand what may be also a problem with the directive as it incorporated the UK's provisions to begin with. So, first of all, in what sense is the directive, according to my research, deficient? Besides others, because it has many provisions. First of all, it adopts a minimum harmonization approach. So it doesn't clarify matters in detail, so it leaves great leeway to member states as to what should be disclosed, how it should be adopted. Then it affords excess flexibility to member states to opt in and out of certain core provisions, as well as It leaves to supervisory authorities the ability to allow for exemptions and derogations from the rules it already has. And thirdly, if we look at the substantive context, and this is where my proposals for reform focus more on today, it fails to regulate adequately the role of the target board. So what are the duties of the board within a takeover context? The disclosure requirements are quite minimal, and they don't attach much value to anything discussed today in terms of sustainability, which may be important for certain companies, especially when one company is to take over another, to see how, for example, CSR policies might be integrated or furthered. Also, in terms of employees' rights, it does have certain provisions in there, but these are considered not to be very effective because of the fact that information and disclosure and consultation is not adequately regulated in the directive. And finally, issues related to enforcement and sanctions, which was something which I considered very important and which was discussed yesterday. The directive also fails to address these sufficiently. So what did the UK rules tell us? What did this Kraft Cadbury takeover show? Well, first of all, from the UK perspective, the role of the target board is not clear. With the Kraft Cadbury takeover, there was an accusation that the board of Cadbury was actually working as an auctioneer of the company as such, not looking after its long-term interests. And of course, this relates to the fact that it's ambiguous as to what duties directors should observe during a takeover context. And just to specify, in the directive we have Article 9, the board neutrality rule, which basically renders the target board a mere advisor during the takeover process, and this is mimicked Rule 21 of the City Code in the UK. So therefore, a proposal was put forward that target directors should take into consideration, are not prohibited from taking into consideration other matters besides the share price when advising, because they do provide a recommendation to shareholders which can steer them one way or the other. Depending, of course, again, on what type of shareholders we are talking about, incentives are important, so it may be the case that they do actually disclose information and shareholders don't pay any attention to that, whereas other shareholders would. So that is an important point to make. But in terms of their recommendation, the problem is that there are no duties or rules that they should follow in terms of what criteria they should have when they recommend or reject a bid to their shareholders. Also, another issue which was raised in the deal is what happens to Cadbury's socially responsible behavior once Kraft takes it over. Cadbury had invested heavily in the use of fair trade products. It also had invested in research and development, as well as in certain local communities in terms of providing jobs to a series of employees. And of course, another issue which came up with the Kraft Cadbury deal, is that 1 minute? Kraft Cadbury deal was the fact that the bidder, Kraft, had made a statement that it would keep a certain facility open, and once the bid actually went through, it said that it was no longer able to follow up on its commitment. So therefore we have also issues of how would one enforce undertakings that the bidder did not actually follow through but made them before during the process of the bid, and therefore another notion put forward was whether we should have negative statements in order to not have an ambiguous disclosure as to what bidders will or will not do with the company's human capital or fixed assets and other investments. So summing, this is just a tester and a trailer for you, hoping that you will actually look at the paper that has my specific proposals for reform. But looking at the directive through the prism of what I mentioned, the Kraft Cadbury deal and the UK debate, it would be interesting to, first of all, define the interests of the company in the directive to include broader interests, and therefore directors would not be prohibited from considering other stakeholders when providing an opinion of a bid. Disclosure requirements, maybe enhancing the information that should be disclosed in the offer document to include the bidder's CSR policies and how these would link with the targets, and also to provide other types of sanctions and enforcement in the directive in order to secure that what is actually disclosed in terms of the intentions for the target company is actually in fact followed through. And these would better help, in my opinion, to achieve a more sustainable model for regulating takeovers at EU level, and also provide legal certainty. One key issue that the failure of the directive is to provide legal certainty, which compromises serving also the interests of other stakeholders in the process. So thank you very much for listening.